Mendez versus Westminster, Segregation of California Schools, 1911 to 1947. The Orange County school system in El Modena, California, established educational policies that resulted in the segregation and discrimination of Mexican American students. Segregation in Santa Ana was first documented in the school district of Orange County in 1913. In 1923, the first segregated school opened in El Modena. In 1919, Santa Ana Senate seat attorney argued the legality of de jure segregation policy by stating that it was permissible for the city to operate segregated schools for people with Indian, Chinese, or Mongolian descent. Even though the law was not inclusive of Mexican Americans, segregation was permissible because of language, age, or attendance. The motion was passed, however, it was notwithstanding that the Mexican organization Pro Patria Club opposed segregation. 1944, Mendez children in Westminster Elementary School. The closest school to the Mendez family was the Westminster Elementary School. Soledad Vidari, the Mendez children's aunt, was responsible for taking the children for their first day of school at Westminster. Surprisingly, the Mendez children were denied admissions. Westminster Elementary only admitted Anglo students. Soledad was astonished. She was informed that her children were admitted due to their lighter skin tones and the Vidari last name, assumed French. This denial sparked outrage in the Mexican community, which later resulted in the filing of the Mendez et al. Case in 1945. The lawsuit opposed Westminster, El Modena, Garden Grove, Santa Ana's discriminatory practices on behalf of their children with Mexican or Latino heritage. Attorney David Marcus was hired to represent the Mexican community. On March 24, 1945, the suit was filed in the 9th Federal District Court to end the segregation of Mexican students on the grounds that the school district violated the 14th Amendment. On February 18, 1946, Judge Paul J. McCormick ruled in favor of the plaintiffs by declaring an injunction to ban segregation of Mexican students. Plessy could not be applied to this case. He further explained his reasoning for not aligning with the infamous Plessy ruling that implied separate was equal. He addressed the issue that was at the core of Mendez's case by stating, "The paramount requisite in the American system of public education is social equality. It must be open to all children by a unified school association, regardless of lineage."
Brown versus the Board of Education was a pivotal Supreme Court case in 1954 that began the slow process of desegregation of schools in the United States. Thurgood Marshall argued the case for the plaintiffs before the Supreme Court. The sitting justices at the time included Earl Warren, Hugo Black, Stanley Forman Reed, Felix Frankfurt, William Orville Douglas, Harold Hitz Burton, Thomas Campbell Clark, Shea Minton, and John Marshall Harlan II. Oliver Leon Brown and Mrs. Darlene Brown filed the lawsuit on behalf of their child, Linda Brown, who was denied access to an all-white elementary school in Topeka, Kansas. At the height of the Cold War, Dwight D. Eisenhower and the United States were struggling to prevent the Soviets from spreading communism. The United States had political interest in showing the world that African Americans received equal rights in their country as they addressed third world countries and the issues of communism. It was in national interest to desegregate, and this interest convergence created an environment in which the Supreme Court could hear a case that would give the United States a more convincing stance against communism because all people in the United States were receiving equal access and rights. The NAACP challenged segregated public school districts around the country, and a lot of other lawsuits were being filed at the time. There was a growing voice of resistance towards the separate and unequal schooling available to the African American community. Cases from South Carolina, Delaware, and Virginia were combined with the Brown case by the time it reached the Supreme Court. The separate but equal mantra of Plessy versus Ferguson was challenged by this case. In this definitive case of 1896, the Supreme Court ruled that segregation laws did not violate the Constitution as long as the segregated facilities were equal in quality. It was ruled in Brown versus Board of Education that it was not equal but harmful for students to be separated based on race because it directly affected their sense of self, their motivation to learn, and their development of self-worth and confidence. Segregated schools fostered a sense of inferiority that neglected any false sense of equality in the segregated school system. While the emphasis of this case was on a more psychological study of the effects of segregation on Black children, the real motivation of the plaintiffs was that the school their child had access to existed as a lesser school than the white school. The Black schools had lower funding, fewer and less qualified teachers, and older and smaller buildings. Chief Justice Warren said, "In the field of public education, the doctrine of separate but equal has no place, as segregated schools are inherently unequal." As a result, the court ruled that the plaintiffs were being deprived of the equal protection of the laws guaranteed by the 14th Amendment. The Supreme Court left the actual process of desegregation up to the school districts.
It was not until the mid-19th century that Chinese immigrants began arriving in large numbers to the United States. Between 1871 and 1884, Chinese American children had no legal access to public education. Chinese children were mostly not permitted, except in San Francisco, to attend public schools until the 1885 court case decision of Tate v. Hurley. After the 1885 Tate decision, many communities established separate Chinese schools. A 19th century California law specifically gave communities the right to establish separate schools for Chinese children. At the segregated Chinese primary school in San Francisco at this time, only grades 1 through 5 were offered, and students who completed the schooling were not allowed to enter the high school, and if they tried to transfer, the board ordered them to return to the elementary school. The Oriental School, later renamed the Commodore Stockton School, opened in 1885 with 24 students in San Francisco. The first Chinese-speaking teacher was not hired at the school until 1926, and teachers were told not to use Chinese in the classroom, and students were prohibited from speaking Chinese in the school or on the playground. For a time, students who needed help in English language studies were considered English handicapped. It was described by one teacher at the time as a sink-or-swim approach. Deed restrictions limited where Chinese could live in San Francisco, and since the 1906 San Francisco earthquake, school segregation had been more enforced than ever. In the late 1960s, San Francisco civil rights activists said that the school board had upheld a system of segregated schools, and desegregation was addressed by a federal court in 1971. Though segregation had been abolished by law in 1947 in California, informal segregative arrangements were enforced. More Chinese immigrants were arriving in the 1960s than before, due to the Immigration Act of 1965. And in 1970, about 13,500 Chinese American students were enrolled in the San Francisco city schools. In March 1970, Lau v. Nichols was filed on behalf of 2,856 Chinese-speaking students against the San Francisco School Board. Of those students in the San Francisco school system, 2/3 were receiving instruction only in English. The attorney, Edward Steinman, represented Kenny Kinman Lau and the other Chinese-American students when they filed suit against Alan Nichols, the president of the San Francisco Board of Education. The plaintiff stated that the school children did not receive a meaningful education when they are taught in a language they do not understand. The plaintiffs made their case on the Equal Protection Clause in Title VI. The Office for Civil Rights interpreted and understood that language could serve as a proxy for race, ethnicity, and national origin, and the students in Lau v. Nichols could establish a case due to exclusion for a Title VI violation. Before the case made it to the Supreme Court, the trial judge and the Court of Appeals had ruled against the students. The Ninth Circuit decided that the school did not have to resolve the disadvantages for the Chinese-speaking students. After 4 years of litigation, the U.S. Supreme Court reversed these decisions and decided in favor of the plaintiffs in January 1974. The main argument that the court accepted was that a meaningful education must use understandable language instruction. The court left it up to the school district, however, to implement the changes to provide accommodations for the Chinese-speaking students.
De jure segregation was the catalyst of the Brown v. Board of Education case. This type of segregation was deemed not legal, which overruled Plessy v. Ferguson in saying that in the case of public schools, separate does not equate to equal. What we see in schools today is de facto segregation that keeps schools almost as segregated as they were in the time of Brown. We see this especially in large metropolitan areas where schools are predominantly Title I, underfunded, and overcrowded. These schools consist disproportionately of minorities. This reality represents the fact that while segregation in schools was deemed illegal in this case, the privilege of white students, the disparity between black and white students, and the districting structure of the United States was not addressed in a way that created a clear solution to truly make schools more equitable. If anything, after Brown v. Board, we see the private school sector become the place in which segregation is perpetuated, and the movement of white families out of cities and urban areas to then fund and create public schools in the suburbs only perpetuates the separation of minority and white students and their educational opportunities. Today, there continue to be court cases which challenge districts to have unitary practices. Examples of cases in just the last few years are Andrews and United States versus Monroe City School Board, which began in 1965 and has continued to the recent year of 2016, where the court still directs the school board to offer equal course offerings at all schools and to ensure the racial makeup and credentials of the teachers do not indicate segregation. Another case, Banks and United States versus St. James Parish School Board, takes place in the year 2017 and directs the school board to desegregate nearly 3 all-black elementary schools to revise their discipline procedures to non-discriminatory ways and to include published statements banning discrimination in extracurricular activities. Finally, Coppedge and United States versus Franklin County Board of Education is a long-standing case which held the school district partially unitary in 2002 in the areas of school transportation, extracurricular activities, school construction and facilities, student transfers, and faculty desegregation, but approved a new order in 2018 in the areas of discipline, which removed students from the classroom and the referral and service of students in gifted and talented programs. These are just a few cases in recent history which continue to write the narrative for more equal education system for our children of today and the future. Much more work still has to be done.